Hey everybody, happy Wednesday. You are here for our Down and Dirty Immigration Weekly Live Roundup. That's a lot of words. We are here to give you guys in English updates on immigration because we do our two shows in Spanish every week. And so our Spanish followers, Spanish speaking followers are always updated, and our English speakers are like, hey, what about us? So we are here for you to give you the updates. It's me and Fidel, trusty Fidel Camposano. Today we are talking about petitioning for your parents. So when a U.S. citizen kid turns 21, they can petition for their parents. Finally, there's many, many millions of families who are waiting for this opportunity to arrive for them. And there's a lot that you need to know about that. So we're going to talk about the ins and outs of that. But I also want to give you, before we get into the topic for today, a quick update on work permit renewal extension. So this is a good news announcement that it takes effect today, the 4th of May. And essentially what it does is it automatically extends work permits for people in certain categories who are applying for a renewal. The backstory, the reason for this is that work permit renewals are taking a really long time, and it's affecting people who apply before their work permit expires, but then they're waiting and waiting and waiting for their new one to come in, and many people lose their jobs in the interim. It's bad. It's a bad deal. So USCIS's solution is to extend the automatic extension of a work permit when a renewal has been filed. So you always need to file the renewal before your work permit expires. That's a key part of this. And it's only for certain categories. So it applies for people with refugee status, asylum status, people who have been granted withholding of removal by an immigration judge, TPS, temporary protected status, spouses of E and H-1B visa holders, spouses of L visa holders, pending asylum application, pending adjustment of status to a green card applicant, some other, obscure case types, which we love to do because they're always so fun, but like registry cases, initial TPS, legalization, life, VAWA, self-petitioner. So it's a limited category, but it covers a lot of people. So if you have any questions about it, just send us a comment or give us a call and we'll help talk you through it. So hi, Fidel.
It doesn't include DACA. So if you have DACA, file it in time so that you don't end up with an expired work permit.
Very good point. And it's taking, I would say give it at least 6 months on a DACA renewal. It's really taking about 2 or 3, but give it 6.
I would say that's a good strategy too.
Rule of thumb. We were talking about on one of our Spanish shows. I'm like, how do you say rule of thumb in Spanish? And nobody knew. It doesn't exist.
Yeah, I don't think it's we had some suggestions, but it's not a common saying, I guess.
Yeah.
So
yeah. Okay.
Cool. So let's get to the theme then that you mentioned about applying for a green card for your parents. So Kate, did you know that in 2019, it was estimated that 17.8 million children in the United States had at least one foreign-born parent, including parents who became naturalized citizens, lawful permanent residents, or were undocumented immigrants?
Wait, how many was that? How many kids?
17.8 million children in the U.S.
Wow. That's amazing. Isn't this country amazing?
Yeah.
Love that.
So to start us off in this topic, Kate, who can petition for a green card, or who can ask for their parents to get a green card?
So U.S. citizens only can petition for parents. Permanent residents may not petition for parents. So you have to be a U.S. citizen either by birth or by naturalization, and you have to be 21 years old. So that's an easy one.
Perfect. And so you have to wait until you turn 21, basically, because I'm sure there's a lot of people, and a lot of those 17.8 million children are waiting to turn 21, I'm sure.
Yes. Oh, yeah. And their parents. Yeah, we have so many. But like, it's so good to know this before. Like you can learn about it when your kids are still teenagers, because it's not as so simple as, boom, you turn 21 and you wave a magic wand and your parents have legal status. Of course. We're talking about immigration. So, of course, it's not that simple.
Right, of course. Just a reminder to like and give us some reactions so we can give you a shout out, and also share this video because I know I will definitely share it with my mom because my two youngest siblings are U.S. citizens. My sister just turned 21 actually.
Oh, happy birthday.
So I will have to share this with her to see if she's eligible. So let's get a little bit more down into the actual law of this.
Okay.
And can you tell us how long does it take if a parent they entered illegally versus if they've never been to the US? Does that make a difference?
Oh, for sure. And this is the big kicker. When a parent has entered with a visa, let's say one time or multiple times with a visa, and they never overstay, okay? When their kid turns 21, their US citizen kid turns 21, we can file, it's called an adjustment of status or a one step. And we file the family petition, the green card application, the work permit application, the sponsorship paperwork, all of it in just one packet. We mail it to CIS. And then about a year later, we go to an interview and mom or dad has their green card, and it's very clean and simple. It is a rare circumstance that things are that clean and simple. We love it when we see it, but for the most part, parents have other stuff in the past. Many parents of U.S. citizen kids entered more than 21 years ago, back when the border was much more porous than it is now, and people were able to come and go without visas, or they had a visa, they overstayed, they left, they came back without a visa because they couldn't renew it, or there's a lot, in a history that's 2 decades old, that's an immigration history. So when it's a clean and easy entry, it's an adjustment of status. When the parent has unlawful presence or multiple entries or entered without a visa, they're going to need a waiver. So if they just entered one time with a visa and overstayed, that's not a problem. If they entered with a visa, overstayed, and left and came back, they're going to have a ground of inadmissibility, depending on how long they stayed. Or if they entered without a visa, they're going to have a ground of inadmissibility. Typically, you could waive that, like in a marriage-based case, or if a parent were petitioning, there's waivers available for those grounds of inadmissibility. But when the kid is petitioning the parent, you can't get the waiver. It's just dumb, for lack of a better word. It's a really messed up part of the immigration system. So the truth is, of these 17 million sets of parents of US citizen kids, my guess is that the majority, more than 50%, are not going to be able to get status through their kids because they have unlawful presence and they can't get a waiver. But here's one way we can sometimes work around it. So here's an example. Let's say a kid.
I think you're going into what I like to think the golden family. It's very, very rare, but
Yeah,
we get so happy when we see this.
it's true, and it gives you conceptually gives you a way to frame this issue, this problem. So let's say a mom and a dad entered the country, they're immigrants. Dad maybe had like an H-2B or some type of work visa, temporary work visa. Mom had no visa, so she entered without inspection. They entered, 20 years ago. They had kids here. They've raised their kids, and now their oldest child is turning 21, and they want to get status, and they come in for a consultation. Well, dad, remember, he entered the one time with the visa, so we can do a one-step adjustment to permanent resident for him, and he'll get his green card. But mom, because she entered without inspection, she can't do that. She entered without a visa. But what we can do is file a one step for dad, file an I-130 for mom, and then when dad gets his green card, mom can get her waiver based on her husband, who's a permanent resident. And then we can continue with her process. And she would have to do the consular process. So that's one way to get around it. There's also, are we going to get into VAWA and parole in place and the questions down the line?
I don't think so. So it might be a good time to bring it up.
Okay. So there are other ways to get around this. Obviously, if you enter with a visa, you can do it as a parent. There's something called parole in place for immediate relatives of people who have served in the U.S. Armed Forces, Army, Navy, Coast Guard, Marines, Secret Service, we learned recently. If a child has served and is either still in service or has been honorably discharged, and their parent entered without inspection, they can apply for something called parole in place for their parent, which essentially gives the parent a legal entry for purposes of green card eligibility. So then we can do an adjustment of status. So service in the military can help by the kid. And then there's also VAWA, the Violence Against Women Act, which isn't just for women. And the way that that can function is that if a U.S. citizen child is cruel in their treatment to their parents, then those parents can get green card status without the help of their kid, and they don't need to have entered legally. So it takes away that legal entry requirement if we do a VAWA case. And of course, parents love their children. And so almost every parent that we talk about this option with is like, I don't want to, no, I don't want to say anything bad about my kid. And it's like, well, but did your kid get into drugs and steal your money and, throw things around the house and cuss you out and, be generally like kind of awful for at least a period of time? If that occurred, then the parent could qualify for VAWA. And if this kid is born in the US, it's not going to hurt them that a VAWA petition was done discussing their behavior. Because it just goes to the immigration agency. It's not like you're filing a police report against them and putting them at risk for getting arrested. So that's another option for parents. If you didn't enter legally, if your kid served in the military, or if there's been some mistreatment in the relationship by your child toward you, then that can open up a hole.
I'd like to touch a little bit more on that last point that you mentioned about VAWA, the police report. So if there is physical abuse and obviously violence that you can see more of, tangible violence, I don't know if that's a category, do you have to file a police report to be eligible for it, or is that not a requirement?
VAWA never requires a police report. Now, if you have a police report, it's good evidence of cruelty, right? But it's not a requirement of VAWA. In fact, physical violence is not required to be eligible for VAWA. It can be emotional abuse, verbal abuse, controlling behavior, manipulative behavior. There's a lot of ways that people can be cruel in a relationship that are not physical violence. So for VAWA, you do not have to have a police report filed. Now, that's different than from the U visa. The U visa is the crime victims visa, and the whole purpose for that visa is to encourage immigrants to cooperate with law enforcement, right? It's a public safety program. So the U visa requires an immigrant file a police report, cooperate with law enforcement, help facilitate charges or prosecution or condena. What's that in English? Convictions.
We're missing our English.
That's the purpose of the U. But the VAWA is the purpose of that is to protect the victims, to protect the immigrant victims of cruelty. So it doesn't matter if you file a police report for VAWA.
Okay, perfect. And then let me just see. So for the folks whose parents entered, like let's say that they have two parents that entered illegally, so they entered without inspection. Is it beneficial to do the I-130 for them? And how, because that it kind of stops there because you can't move forward with the waiver.
Right. So the I-130 is not going to get them legal status right now. It's not going to get them a work permit. So it in some ways could not be, helpful. But in other ways it could. I mean, it gives them a document, an I-130 official USCIS document that says this person is an approved beneficiary who is the parent of a U.S. citizen child. And so that gives them something that they can carry around with them. Sorry, my daughter is calling me because they have a phone now, which is like a whole new world. But it gives them a document they can carry around. And so like in places like Texas, this ridiculous state that we live in, where police officers in rural areas can act like immigration agents, but of course they don't know anything about immigration, and they pull someone over and they ask them about their status. Like, you have this document that you can show that you are in some sort of legal process and you're the parent of a U.S. citizen. And so if it were me, I would feel more comforted as an undocumented parent to have this piece of paper that I can carry around with me. And it'll also help if there is immigration reform, if there are changes in the law. It sort of gets you ahead. But it doesn't technically at this moment give you legal status.
Okay, perfect. And Kate, does the child need to have a specific income in order to petition their parents for their green card?
Yes. So in order in any immigration case where a petitioner is, petitioning a beneficiary, the petitioner or beneficiary, those are like terms that we use. The petitioner has to earn a certain level. It's 125% of the poverty guidelines. So like for a family of two people, I think it's, around $20,000. It changes every year. And the petitioner has to show their tax returns, their check stubs. They have to fill out this contract with the government that says they're going to maintain the immigrant at a minimum level. So there are requirements around that. But if you don't earn enough, let's say you're in school or you're out of work or whatever, you can get a joint sponsor, and that person can be anybody. It can be a friend, a neighbor, a family member, just someone who's willing to help. And they can submit their own financial records, and they make their own promise to be helpful, be a part of the case, and that can get you over the hurdle. And I can only think of, one or two cases that we've had over the years, fewer than 5, where we had a petitioner who wasn't earning enough and couldn't find a joint sponsor for the case. Pretty much everybody that runs into that hurdle, everybody worries about the hurdle, but I will also say my experience is that everyone who runs into the hurdle figures it out and they find someone to help the family.
Awesome, awesome. And let me, before we continue the questions that I have, there are some interesting questions in the chat. So let me just go ahead and give a shout out to everybody that's joining us. So we have Daniela Aguirre, Jenny Briseño, and she has a very interesting question that we forgot to mention.
Jenny's bringing the good questions.
Yes, it's another option for those that entered without inspection, but we'll talk about that in a second.
Yeah.
Then Aaron Polendo Luevanos is also joining us. Thanks for, it's nice to see you, Aaron, here in these English lives. You're always joining our Spanish ones, but it's nice to see you here too. And then Eduardo Molina and Carlos Cruz Martinez. Thank you everybody for joining. I hope that you're all sharing this video so that your friends and family can also get this information. And then we have comments from YouTube. So Joshua Carter sends us emojis with face with little hearts. And then Jessica Infante sends us hearts as well.
The yellow hearts, my favorite is the yellow one.
And Cesar Lopez has more of a comment. So dice, yo ya tengo casi el año esperando respuesta de inmigración sobre el FOIA y nada. Kate, what can you share with him about his FOIA?
So, cuando alguien, I'm going to answer this in Spanish because this question was in Spanish, pero un FOIA es una solicitud para revisar un expediente con cualquier agencia de inmigración, que puede ser la Corte de Inmigración, Border Patrol, el Servicio de Inmigración, el FBI, ICE. Todos tienen un proceso de pedir copias de expedientes y diferentes tiempos de procesamiento. Y hay unos como el FBI, es como semanas, y hay otros que tardan meses y meses. Un año es demasiado, en mi opinión, entonces sería buena idea chequear lo que está pasando con esa solicitud, y quizás hay una manera de pedir la información en otro lugar. So, eso parece un poco raro a mí. What I said in Spanish is that with a FOIA, Freedom of Information Act request, that is where we get copies of people's applications and history, their file with different immigration agencies or any federal agency like Border Patrol, U.S. Citizenship and Immigration Service, immigration courts, ICE, FBI, and they all have a different way, a different process, and they all have a different processing time. Some are way better than others. And so sometimes it shouldn't take a year. Sometimes it can take months. But if it's taking a year, it might be a good time to reassess what information are we trying to find out? And is there another place where we can look? Because sometimes, we're looking for someone's border apprehension information, and there's a couple of different ways we can get that kind of info, and some are better than others and give us different stuff. And the whole getting information from a FOIA is a whole separate subsection of immigration law. And it sounds like it should be simple, like, oh, get a copy of your file. But I assure you, it is not simple. And our legal assistants are like amazing at FOIAs. They're very expert because we do a lot of them. In fact, we just did a review of a bunch of our cases, and it revealed that one of our major, like top 3 case types is FOIAs, but it's because we're really careful with people. And anytime we get an indication that something could be an issue for them, before we recommend whatever, citizenship, green card, filing something, we want to get clear on what's in the record first so we don't ever put anybody at risk.
For sure. That's very important.
Mm-hmm.
Cool. And then Jenny's question right here. So dice, hola abogada, yo quiero saber cuáles son las reglas de la ley 245I y si mi mamá califica para ese programa.
Muy
Saludos.
buena pregunta, Jenny. Gracias. So, esa es otra manera para poder ajustar estatus dentro de los Estados Unidos sin tener que salir, sin necesitar un perdón para personas que entraron sin visa. Eso fue una ley pasada en el año 2000 que dice que si alguien fue pedido en una petición familiar antes de la fecha 30 de abril de 2001, aunque fue otro peticionario, su tío a su mamá o algo así, si alguien estaba incluida en una petición metida antes de esa fecha, que fue una petición familiar o una petición de un empleado, esa persona puede ajustar estatus ahora basado en otra petición metido por su esposo, su hijo, otra persona, y ajustar estatus sin tener que salir, sin necesitar un perdón. Hay una multa que tiene que pagar para esa ley 245I, es $1,000 más en la cuota que se paga, pero es otra manera de calificar para padres de ciudadanos. So Jenny had a really great question about the 245I program. So remember we talked about for parents, you have to enter with a visa or parole in place if the kid has served in the armed forces, or VAWA if there's been cruelty. And Jenny brought up the fourth way, which is 245I. And basically the way that functions is if mom or dad was ever included in a petition before April 30th, 2001, an immigration petition, they can adjust status even if they entered without a visa and they shouldn't need a waiver. And that could be like, they don't have to have been the subject of that petition. So in lots of cases, we see like maybe an aunt petitioned for a parent and the kids were included automatically. That counts as a 245I. So that's another way that people who enter without a visa can get in and adjust through their 21-year-old children if they were included on a petition a long, long time ago. And that would be something that we often FOIA, for example. We get parents who come in and they say like, yeah, I was petitioner. My dad petitioned for my mom when I was 5. But no, we don't have copies of anything because that was more than 20 years ago. So we'll do a FOIA, get those copies, and then we can do a 245I adjustment.
And we also get very excited when we see those cases.
Super fun. We love
brand new opportunity.
Yeah, because these are people who have been waiting for decades, and it's very, very fun to finally get some resolution.
For sure. So then Catherine also says, hi all, thank you so much for joining us, Catherine. And then another account that usually sends us really good questions, Law Student's Nightmare. Thank you for joining us. And it's his question or their question. I don't know what their pronouns are, but it says, I know that if a citizen petitioned their partner, they can wait, I believe, 3 years to be a citizen and wait around 5 years if the resident is doing it alone. Do parents fall under the same rule?
Yes. Well, no. So you're right. So when someone gets their green card, they are eligible to apply to naturalize or get their citizenship within 5 years of their green card. And they can file the M400 application 90 days before the 5th anniversary. So you can file a little bit before the 5th year. That's the rule for everybody except for spouses of U.S. citizens who have been married and they've been together for under 3 years. They've been living together for 3 years. So then you can do the 3-year rule. Parents of U.S. citizen kids have to do the 5-year rule.
Perfect. And then Yunwen is also sending us a shout out. Hola, thank you for the information. Thank you so much for joining us, Yunwen. And we have another question from Law Student's Nightmare. It says, also, what happens if the parents are cousins or somehow related? Does this disqualify them for residency, even if their child is a citizen and petitioning them?
Oh, man, this is a good one. Y'all are bringing the good ones. So we've had a lot of these related marriage case questions for like first, second, third cousins lately. And I'm pretty sure the latest research is that we have to go by whatever the jurisdiction where the marriage is going to occur says. So, like, if, I don't know, Texas, for example, allows second cousins to get married, then a marriage based green card case in Texas will be allowed. But that's not really what you're asking here. What you're asking is, can a child who has parents who are related to each other petition each parent? My guess is for sure that you can, because there's no requirement that the parents be married at all. Like, this is not about the relationship between the parents. This is about the child to the dad, the child to the mom. And so who cares whether they were married or not? So yes, I would say that that kid can petition those parents regardless of whether they can legally marry.
That's very interesting.
I know. I love it.
I'm
when
like thinking of like maybe a loophole for those that can't do marriage based.
Oh, true. But usually I feel like the ones we've had, they're like young, or they don't even have kids yet. You know, it's like an arranged marriage, or, you know, stuff like that. So
Yeah. Okay. So to follow up, Jenny has another comment, and then she says, with 245I, are applicants' beneficiaries required to leave the country to a consular interview? And then she
no.
says, thank you for your time.
Thank you, Jenny. And the answer is no, they don't have to leave the country. That's the beauty. That is the beauty of 245I, is it allows eligible people to adjust status inside the country. They don't need a waiver. They don't have to go to the embassy abroad. All they have to do is pay that extra filing fee, the $1,000 filing fee. There are some different documentary requirements depending on when the I-130 was filed. That is probably not going to be of interest to most people watching this, but like, you do have to show physical presence in the United States in 2000 if it was filed before 2001. And so we get into evidence and some stuff like that. But generally, it's, you know, if you were included in a petition for since before April 30th, 2001, and you've been in the US that whole time, like it will disqualify you if you've left and you've been out of the country. But if you've been here waiting, you were petitioned a long, long time ago, then you get to adjust status here.
Perfect. And there's so much more that we can talk about this, Kate, but our time is running out. So the more common question that we often get is, can I petition my parents if I have a criminal record? So I guess this is the same for, like, I don't know, spouse-based. Like, can you tell us a little bit more about whether the petitioner's criminal record
Right.
matters?
So we're always looking at the beneficiary's criminal record, because there's many ways that an immigrant can be disqualified from a green card based on criminal history. With the petitioner, we don't usually worry about it, but the only area of concern is if the petitioner has any conviction that relates to, you know, sexual harm against a child. So it can be lots of different types of convictions, but if it's within that realm, we need to pay close attention. That's called the Adam-Walsh Act, and it's a way to protect, you know, immigrant kids or spouses from predators. And so it can block immigration petitions. And that's another whole area of the law where if a petitioner has a certain type of conviction, they may never be able to petition anyone. But there are lots of ways to sort of research and investigate whether a crime falls into the Adam-Walsh Act, and if it does, what you can do. So anyway, it can matter, but not if it's anything that's not sexual assault of a child, it likely won't be an issue at all.
Wow, very interesting. You learn something new every day. That's new for me.
Oh, really?
So yeah, I didn't know about that before. So, but I'm not doing cases, so that's great.
Perfect. Say that with so much joy.
Yes, for sure. But thank you so much, everybody, for joining us and for all your questions. They were wonderful, and we appreciate them so much because it brings something more interesting to the conversation that we're having. So thanks, everybody, for joining. Kate, any last comments or any last info that you want to share?
Nope. We covered it. Thanks, everybody. Appreciate
it. Perfect. Thank you so much. And we'll see you in 2 weeks, right?
Yes, every other Wednesday.
Awesome.
Bye.
Okay.